Hi guys, welcome back to Nairobi Legal Insights. In this video, we're going to be looking at another element of a valid contract, which is consideration. As far as elements of a valid contract are concerned, consideration is our next step on the road to understanding contracts. Previously, in the past two videos, we've learned what it takes to create an agreement. But one thing we need to note is that an agreement is not necessarily a legally binding enforceable contract. So please take this seriously. Just because you have an agreement, it may not actually be legally enforceable. So we need to appreciate again that lack of consideration is one of the reasons that may prevent an agreement from becoming a contract. And without consideration, a promise is just a promise and nothing more. So you need to be very careful as we learn what consideration entails. When we talk about consideration, we need to appreciate that this is the price or the promise that causes parties to enter into a contract, and consideration forms the basis for parties' exchange. Now, just to give a bit of context for you to understand what does consideration mean, if Kamau sells his laptop to Njeri at 55,000, the 55,000 becomes consideration. And in this case, you can clearly see that Njeri will receive the benefit of the laptop, and her detriment will be to surrender 55,000 over cash to Kamau. So in this case, an agreement now is a legally enforceable contract because there is consideration in the picture. We also need to appreciate that the overall central idea surrounding consideration is that contracts must be a two-way street. And actually, in most cases, if one side receives all the benefits and the other side gets nothing, then in this case, an agreement is considered to lack consideration and is not an enforceable contract. Remember that consideration is proof that parties intended to be bound by their promises. So remember again, taking you back, in addition to offer, acceptance, intention, consideration is another element that actually makes a valid contract. When we talk about consideration, we need to appreciate that this consideration can be money, it can be insurance, or it can be a promise not to sue, or anything of value to the promisee. And the case in question here is provided on your screens. As a law student, consider reading this particular case, but as a business law student, you just need to understand the principles that underlie consideration. The next thing to note is that consideration involves reciprocity, in the sense that parties must have bargained for whatever was exchanged and struck a deal, meaning that if you're doing this, I will do that. There has to be something of measurable value that is actually moving from one party to another. To put the previous two explanations into context, I want us to look at a scenario whereby an agreement can fail to become a contract for lack of consideration. Now, imagine Wanja works at Java and at around 10 a.m. she is in a very good mood, promises to buy her coworker a burger during lunch time. Now, of course, the coworker is very excited and agrees to this offer. But in the course of that morning, that coworker goes ahead to be very rude to Wanja, and Wanja changes her mind about buying that particular burger. In this case, Wanja is actually free to do so. You may wonder why. Remember here there was an agreement, but Wanja has cancelled that agreement and she's actually free to do so. The reason why Wanja is free to do so is because her promise was a one-way street. Remember, we said a contract must be a two-way street, in the sense that there must be consideration in that contract and there has to be an element of reciprocity, meaning that someone must do something and someone else must do something in return, meaning that there has to be an element of consideration. Taking you back to the first example I gave you, when you buy a laptop, the person selling to the laptop will get the money while you get the laptop. In this case, Wanja was getting nothing in return. And so furthermore to this, the coworker received all the benefit, and this benefit was to actually get that burger, while Wanja was getting nothing in the process. And so as far as this particular scenario is concerned, there is no contract because there was no consideration in the first place. Before we discuss the rules of consideration, I want us to first find out how this element of a valid contract applies in a practical context. Now let's read this question so that we are on the same page. Now imagine Bahati has been rapping the entire day and he turns out to be very hungry. He drives to Maritas in the parking lot of Magharibi, but it turns out that Maritas has been closed. Now in this situation, luckily for Bahati, the Shack burger is open, and while Bahati is walking over to the Shack, he realizes that he left his M-Pesa phone at the studio. Now at this point in time, Bahati is frustrated and reaches out to one of the guards to borrow 250 bob. As you can see from these facts, the guard goes ahead to say, I cannot just give you my 250 bob just like that. Maybe you can sell something to me in return. Now the facts go further to show that Bahati cannot believe this, but he nevertheless goes ahead to remove his gold chain. He hands it over to the guard, and the guard in return gives Bahati 250 bob. Remember here they have made a deal. In this case you might wonder, is the guard entitled to keep the expensive gold chain that Bahati has actually handed over to him? Now having read and understood the previous question, this is the analysis you need to perform as a student of contract law so that you can tackle that previous question. We need to appreciate with the previous discussions we've had on consideration, and before we go into the rules of consideration, that even in extreme cases, courts rarely take an interest in how much consideration is given. Now remember, whether a deal has been very good or not to the parties involved, the court rarely takes an interest. Now in this particular scenario, even though the gold chain is worth $1 million, the 250 shillings that was handed over to Bahati is still consideration, and it will actually count as valid consideration. Remember, as we go into the next slide, we are going to be talking about consideration, and consideration need not be adequate but sufficient, meaning that even if that gold chain was worth $1 million and the guard was able to pay 250 bob for it, then that consideration is sufficient. Now the result of the previous question we talked about, specifically the transaction, is that Bahati may have second thoughts, but they will be too late. Remember, in this particular scenario, the guard committed an act by handing over his 250 bob, and he was under no legal obligation to actually give Bahati the 250 bob. And so we need to appreciate that also Bahati received something small but measurable value, and this is consideration. And so furthermore to this, there is consideration to support this particular deal between Bahati and the guard at Magharibi Place. And in this case again, Bahati will not actually get his gold chain back. This is how consideration works. It does not have to be adequate but sufficient. And this question is going to lead us into the rules of consideration. Remember, however little that consideration is, so long as there is a deal, it will be considered to be sufficient for that particular bargain. With reference to the analysis that we used to answer the question before, I want us to discuss the rules of consideration. And the first rule of consideration is that consideration need not be adequate, but it must be sufficient. Now, as a student of contract law, you need to appreciate that the value to each of the parties need not be equal, but it must be legally sufficient. I want us to appreciate this statement through this example that I'm going to give. Now, assuming Okello agrees to sell his Prado to Maina for 150k, in this particular instance, the consideration of 150k is considered sufficient for this particular transaction. And so, even though the market value of the Prado is 4 million, it will not matter. The point to note about this statement is that the fact that consideration is not adequate does not matter, meaning that even though this 150k will not match the market value, that will not matter. So long as there's some economic value that Okello is getting by selling his car to Maina, then in that case the deal will be considered valid and there will be a valid contract existing between Okello and Maina. The next point we need to note is that once parties have agreed and there is valid consideration that exists, the court will at all times hold parties to their bargain, because this in this particular situation, Maina bargained for 150k to actually sell his Prado. And so we also need to know that the court will not seek to rewrite the contract for the parties, meaning that the court will only look at the contract you wrote. Was there consideration? What did you agree on? It will not matter however little that consideration is, it will be deemed sufficient for purposes of that specific transaction. And if you want to appreciate this principle further, consider reading this case. It can be found in Kenyan Law Resources so that you understand how the court looks at these questions to deal with consideration. The second rule of consideration is that consideration must not be in the past, and what we mean here is that these are actions that are done before a promise. And for you to understand this, we have two examples, one of good consideration and the other of bad consideration. In our first example, Joyce agrees to pay her watchman in Njoroge a sum of 15,000 to clean a compound and plant flowers along the fence while she's away on a work trip. Now, Njoroge goes ahead to actually do this task, and he leaves behind an invoice of 15,000 for Joyce. In this example, Njoroge can be able to enforce the payment of the 15,000. Now, in the second example, this is a situation where we have bad consideration, and as you can already see, Njoroge watchman decides by himself, no one has told him, to plant flowers along Joyce's fence while she's out of town. And when Joyce returns from work, she's extremely happy with Njoroge's kind act and in fact promises to pay him 15,000. Now later, of course, Joyce refuses to make this payment. We need to appreciate as students of contract law at this point in time that Njoroge cannot enforce the payment. This is bad consideration. Remember, the second rule of consideration provides that consideration must not be in the past, meaning that there are certain actions that can be done before a promise. So in this second example, Njoroge's action of planting flowers along Joyce's fence were done before the promise to pay the 15,000, and so in this particular instance, Joyce is at liberty to refuse to make the payment because either way the 15,000 was bad consideration. To appreciate these principles, please consider reading these two cases so that you grasp the legal principles behind this rule. With reference to the bad consideration example where Njoroge simply just wakes up to plant flowers along Joyce's fence without instructions from her, I want us to look at the conditions for the exception to the past consideration rule. Now, how can we change Njoroge's situation in the second example that we discussed previously? Number one, the act must have been carried out at the promiser's request, meaning that Joyce must have actually requested for that to be done. Number two, the parties must have agreed that the act would be rewarded in some way, meaning that Njoroge should have reached out to Joyce and they should have agreed that there will be some reward if Njoroge goes ahead to plant the flowers. And number three, the payment must have been capable of legal enforcement had it been promised beforehand, because also remember that there is payment that may not actually be capable of legal enforcement. So please remember that we also have conditions for the exception to the past consideration rule. As a student of contract law, this is an exam strategy that you can use when reading on the topic of consideration, and these are the key cases you must have at the back of your mind. And on the other side, if you're doing business law, all you need to understand are the principles that underlie consideration. And the reason why I'm emphasizing these cases is that for law students, anytime you're making a discussion, you must actually use case law to back up statements. This is still an outline that you can use as you prepare for your exams, in addition to the previous framework I've provided as far as the topic of consideration is concerned. In case you haven't subscribed to Nairobi Legal Insights, please consider doing so that you receive notifications every single time we post a new video. You can also share this video, and if you liked the content, you can give the video a thumbs up. In our next video, we're going to be looking at capacity, which is another element of a valid contract within the Republic of Kenya. Thank you.